Welcome to IP Tech Tuesday number 69. Today we're going to talk about how IP and contracts interact with each other. The crux of the issue is the following. IP is very powerful. You can block somebody, you can get an injunction, you can sit in people's heads. And maybe that's why patent attorneys, most of our work is drafting patents and prosecuting them. We believe that the real asset is IP rights, and these pesky contracts are just to say, who's allowed to use it and stuff like that. But not really. I'm sure all of you have seen companies where they have good patents, but these good patents are not translated into value. And one of the interesting things is a lot of these companies believe that a patent is something that you sue with. And in fact, had more than one person tell me, I don't want patents because I'm not planning on suing anybody. And I'm also not planning on suing somebody who sues me. So the issue becomes, how do you get usable power? And one of the ways of looking at it is that IP is potential power, and contracts are what makes that power usable. So as we go through the presentation, focus on this one idea, that IP by itself often doesn't do much. And what makes IP live in the real world, maybe less in startups, is contracts. And in case this is too big an idea, a much simpler idea is that IP actually lives in contracts, not in the courts. It's very unusual to get to the courts. So let's talk a little bit more about contracts. First of all, contracts are a critical tool for leveraging IP. It's difficult to use IP if you don't have a contract, other than suing, which is expensive and can backfire because you can lose and so on. And also in the other direction, contracts work much better if you have IP. Why? Because whenever you work with somebody, there's always going to be a potential flow of knowledge or other types of IP which you want to control. And that's what contracts do. And if the contract ignores IP, then it ignores it. Now, it is true that you can use contracts to license IP, but that is in fact not the main thing that you do with the contracts. Two examples. One, you can use contracts to control how IP flows, talk about it later, or how to control an ecosystem. Now, I'm not planning on giving a tutorial on how to draft IP contracts. That's what we have IP lawyers for. But I want to give you a feeling for how IP interacts with contracts, and how this gives you all sorts of possibilities. Particular, how do contracts make IP work, or how do contracts interfere with IP working? And the classic example is that a contract can help you build an IP moat. They can, work together, or they can interfere with building a moat. And a very typical example is that a contract gives somebody some rights in your IP, and because somebody has some rights, it's much more difficult for you to assert all of your rights. One more important thing about contracts are usually between two parties, party A and party B. And you might think that it only relates to the relationship between these two parties, but the same way IP can be used also for people who are not in direct relationship, also contracts have a big effect on parties that are not part of the contract. And perhaps for this reason, contracts are actually crystallized IP strategy. Now, usually the strategy is only implied in the contract, but the contract definitely reflects the positioning you're trying to use and the tools. It also means that these contracts are not neutral or not standard, and they always encode, and it should be intentionally, all sorts of assumptions, your priorities, and your blind spots, which of course we want to avoid. Sadly, a lot of people sign contracts in a way that is unconnected to the intended strategy. That is, of course, not good, especially if the contract is a crystallized IP strategy and it doesn't match what strategy you actually want to do. That's a built-in misalignment. I'd like to quickly go over some contact points between IP and contracts. First of all, some types of IP cannot live without contracts. For example, trade secrets. You can't license it to anybody unless they commit contract to confidentiality. Other types of IP don't really have many or enough laws to protect them. Data and trust and know-how, and if you want to leverage them, it's quite difficult. Contracts are very important to prevent damage to your IP. Imagine that you sign a contract to allow somebody else to use your trademark, and they use it in a way which harms your trademark. Well, why didn't your contract say something about it? Contracts also help link non-IP actions to IP actions. For example, marketing or valuation or money. We like money. A very important thing the contracts do is regulate the creation of IP and the flow of IP. And that includes, for example, ownership and IP management. And all of this, how should I say it, is especially true with new IP. Remember, a lot of contracts talk about what is now, but IP is always being created. We'll see in a second that IP can help the contract actually happen. We often see IP as being static, but contracts can bring it to life. Contracts can be used to modulate your rights. If you have, let's say, a patent, the only right you have is to sue somebody if they're infringing. Like I said before, it's a big hammer, it can backfire and so on. But if you have a contract, the contract can modulate it. And it can change this permission to sue into money. We call that perhaps licensing royalties or cross-license. If you want to look at it in a slightly different way, the IP rights exist by law, but they actually live or die based on the contract. The law, let's say, creates defaults, but until they come into being, you can wait years. But if you have a contract and both people keep it, yes, I know they don't always, then it not only creates a reality, it also works quickly. And just think about a few more rights that there is no good default law about them. Residual rights, ripple rights, that are created from the IP. IPs that you didn't know that you actually needed. Okay, it's not in the contract, so by default you don't get it except you actually need it. So you can even have contact between the contract and IP that doesn't exist or that you're not aware of it existing. Look at it from the other side now. IP can be used to tie in a contract. People sign the contract, and let's say as an incentive, they keep on following the contract because you have IP. In other examples, IP is being used as a moat. And I'm only mentioning that because the best thing to do is to use a contract together with IP to build a moat which is non-IP. Okay, people sign with you because of IP, but then as you get bigger, more control of the ecosystem, people continue to work with you even if your IP didn't exist anymore. Now, why is that important? Because if IP is the only incentive for people to work with you and follow a contract, you're in a bad place. Even though we love IP, IP is generally weak, should I say sensitive. It can suddenly die. And, people, best kind of contract is where both sides have a good reason to keep it, like a Nash equilibrium. So you use a contract and the IP to build these business reasons, but after that, you want the contract to do the job. And I talk about it as IP being used for profit. Let's say a pajama maker licenses Mickey Mouse from Disney. Both sides make a profit. The pajama maker can sell a pajama for more money, and Disney gets money. And it can also be used for fear. If you don't fulfill my contract, I'm going to sue you. Now, I don't know how many of you spend all day reading contracts, but imagine that you are a startup company and you probably have a closet or directory that has lots of contracts in it. You probably don't read them. Not every day, not every week, not every month, and not every year. And this causes all sorts of failure modes when you have IP and a contract working together. The first one, people can simply forget what they need to keep secret or other requirements of the contract in order to protect the IP. Even if people don't forget it, IP is complicated and they might misunderstand. And of course, people can simply lie to themselves and say we're allowed to do it. So one of the things that IP does in order to help contracts succeed, surprisingly, is injecting uncertainty. Imagine the following. Company A talked about Disney and a pajama maker. And pajama makers selling pajamas with Mickey Mouse under contract to Disney. And guess what? The money's starting to come in. It's working. It's working so well that the pajama company can now start calculating what happens if they stop the contract and stop paying Disney money. What's going to happen? The fact that Disney has IP in the form of trademarks and copyrights makes our pajama company not so sure exactly what's going to happen. And that gives them fear of the unknown. So if the pajama company is thinking to break the contract, this being worried about what will happen with the IP can help the contract continue. Now, if you've read contracts, a lot of them deal with real stuff. IP is often the easiest part to damage one way or another or get an advantage in the contract. Let me just give you an example. IP, for example, know-how, is often tied to people. But the contract might be about companies. The people leave, you're left holding nothing. Continuing the issue of uncertainty, when you have an agreement about IP, you have all sorts of risks and challenges. A risk is something bad might happen. A challenge is you're going to have to spend money in court explaining why everything's okay. Maybe your IP will become invalid. Maybe it will cost money to sue somebody. Maybe you won't own the IP. Maybe it costs a lot of money to have the IP. Now, I call these things risk, but a lot of them are actually a combination of risk and uncertainty. So on the previous slide, I said IP can be used to provide much needed uncertainty. But if you have a contract with somebody else and you have all of these risks and uncertainties floating around, one of the things that contracts do is they help decide who bears which one of the risks. So you bear the risk that the machine won't work, and I bear the risk of invalidity of the patent, as an example. But more important than risk is the issue of uncertainty. Which one should be unsure of what's going to happen? And even more important, when will they have to have that uncertainty? Let's say we have litigation. We have a small company. They don't have any money. They signed a contract with a big company and got some technology from them. But this technology might be infringing a patent. So if somebody sues a small company, it could be game over because they don't have the money to deal with it. So one way is we can move the uncertainty to the big company. And the other way is we can change the time of uncertainty. The big company commits to pay the money. And if they lose, then the small company has to do something. That's going to be a few years later when the small company is more able to live with uncertainty. Let me give you a few examples of reducing risk or balancing risk. If your contract says that you not only have to pay a patent license fee, you also have to pay a technology license fee, then even if the patent dies, you still get a fee. And even if the technology doesn't work, if the patent is still alive, you still get a fee. So the risk that you have goes down. Different type is patent pooling. Company A and company B pools their patents. Now the risk of company C coming and not infringing anything went down. I want to talk again about indemnity, which is that if somebody is sued, they get made better by a different party. And go back to the example of small company and big company. Imagine again our pajama companies, they might get sued for trademark infringement, not by Disney, but by somebody else. Because maybe Disney's figure is somehow infringing a trademark. If you don't have any contracts, you can sue them you can sue Disney, the small company can sue Disney for giving them a bad product, but only if you survive the court case. At the same time, we often attack the small companies in order to put pressure on the big company. And why does it put pressure on the big company? Because the small company knows that if they get sued, it's a sudden shock to their system and they can't deal with it. So if the indemnity is worded correctly, it might not have any effect on the risk or on the amount of money. And the only thing it would do is reduce the leverage of the person suing because they don't have a shock effect. One last thing about IP regarding FUD. FUD, people don't know, is fear, uncertainty, and doubt. It's a tactic beloved by some software giants, and they make people not sure what's going to happen. So one of the reasons IP is powerful is because you don't know what's going to happen. You can have big upsides and downsides. It's very difficult to predict what's going to happen. And the contract can tame this uncertainty by balancing with risk or with fines, or it can hedge sources of uncertainty, or the opposite. It can create uncertainty. I mentioned patent pooling before, increases the uncertainty of others. Or we can use IP. In other words, two sides have a contract. and it makes one party build a system that is more likely to infringe if they decide to leave the contract. Think again about Pajama Company. Because they're getting cute things from Disney, they can't really, it's more difficult to sell pajamas that are not infringing Disney's trademarks. Or you can make your partners build a system which is much more sensitive to interruption. And I'll say again, one of the powers of IP is sudden interruption. Now, you can't do any of these things that I said if you don't identify the risks and uncertainties that are either mediated by IP or reduced using IP, and then the contracts have to take this into account. And of course, different types of IP and different individual items are different. And I'll say again, this is not about the wording of any particular IP clause. This is about knowing how the contract is controlling your IP. So one metaphor I think is very interesting, because IP is simultaneously very powerful but sensitive, is operating systems. One of the jobs of an operating system is to prevent the idiot user from misusing the hardware. And all of these things I'm going to say now is exactly the type of things that an operating system does for hardware. It defines protections. It tempers it so you can use less than full power. It channels the IP power, and that's a lot like APIs, application program interface, or services of operating systems. Anybody here who's done software knows that you don't interact with the operating system. You have a few connections, and you connect through one of these connections and ask for what you want. And that's exactly how many contracts are built. It helps fill in for the weakness of IP. And because it's specific, it helps define and guide how you're going to leverage the IP. So if you do your contracts correctly, the amount of uncertainty in applying the law between the two parties can go down. I mentioned before you might want it to be up, but you might want it to be down. You can look at contracts, if you're more of a lawyer, as your own personal regulations. You know, there's the laws, there's regulations, and there's court cases. And by having these regulations, you can make litigation much less likely, because they do matching between bad things and punishments. If you can allow your partner to do something small and get a small punishment, sometimes it helps you avoid litigation. Computer operating systems are super reliable, contracts are not. I don't want you to get the ideas that I think that IP can only be wielded or its behavior modified using contracts. There are other things as well. I gave here two examples. One of them is assertion behavior, and one of them is expectations. If people expect the IP to be a problem, and you can help them do that, they behave differently. And if you have patents which you sue on, or patents that you don't sue on, then it also affects how people react to your IP, even if they don't have a contract. A different metaphor for IP is bundling and unbundling. So IP is a bunch of rights and weaknesses and abilities, and we only have a small number of IPs. But for example, if I have a patent, I can sue you. But if you want to sue somebody else with my patent, you can, because it's not your patent. But we can have a contract which will allow it. More generally, you can have monetization without ownership. I can license out the patent. There's a lot of ways that we can make the patent work without changing the ownership. And a few more legal rights we might want to unbundle. Monetization, creation, ownership, leakage. I want to prevent leakage or cause leakage. I want to control how IP is developed or how IP is used, exclusivity, reliability of the IP. Let me give you an example of a contract unbundling a weakness. In some countries, perhaps most, a trademark is only valid if it's actually being used. A contract can require my other party to use a trademark so it stays alive. Another type of contract, when you leverage your IP, you sue somebody, it costs you a lot of money and you can't afford it. But I can contract out the right to sue to somebody who has that kind of money. Cause and effect. Litigation can take a year, 2, 3, 5. Obtaining a patent can take a while. The contract can unbundle that and say, if I filed for a patent, you have to pay. Forget the antitrust issue. And you can also do bundling by tying together. You get a license only if you do such and such. And all of this bundling and unbundling creates hybrid business tools, which can affect other parties in an interesting way. People want them. People say, I want to have that bundle that company A is providing, which includes the right to use the IP, no risk of infringement, and so on. So what you have to think about when you bundle or unbundle, or one of your reasons for bundling and unbundling, is you want to control the possible failure modes, which means, guess what? You need to figure out what they might be. IP and contracts have what I would call a natural life cycle. In the ideal world, they're aligned. In the realistic world, even if they were aligned, they start moving apart. And one of the ways they move apart is the type of IP you need at a certain stage of a contract is different from the type of IP you need at a different stage, and vice versa. The way a contract can help IP at one stage of the life of the IP is different from another one. And the way I see life cycle, it also includes what happened before the contract and IP and what happens after. So what do we look at? We look at business goals. And what do we ask? You ask, did our business progress the way we wanted because of this life cycle? Were we able to build a sustainable moat? Did we create some dynamic capabilities we needed? Did it help us build an ecosystem? Start with IP. It's simple. When do contracts matter? Well, when you create them, even if you created before the contract, because a lot of times the cooperation started before the contract. Or IP might be created while you're negotiating the contract. Why? Because now you know what the other side needs. Sometimes the IP is created only after the contract, and sometimes that's a goal. And what about if IP is created after the contract is over? And this IP, which is created, besides asking who owns it, does it have limitations on it due to the contract? IP, after being created, is prosecuted or damaged. I'll explain why I put them together. Prosecuted means a patent office does something, and damaged means we do something. And guess what? I have an office action. And what I do in the office action depends on what my contract is trying to use the IP for. Or I gave an example before of somebody having a trademark and diluting it. Again, it's a place where you have to look at the alignment. When IP is monetized, that's the natural place to look for contracts. And also when IP is asserted, there's always contracts involved. Last but not least, the IP is dead, it's finished. It still has ripples, secondary effects, consequences. Hopefully the contract relates to them. Now let's look a little bit more at the contract side of things. Here's up stages, and now I'll go through them one by one. You want to craft your IP to encourage people to sign a contract with you. And part of it might be as a marketing function, which means people need to know that there is IP, that the IP is available, and that the IP is useful. Sometimes the IP does it all by itself. Sometimes you actually market your IP or your technology, but then you write patent pending. There's no contract yet, but it's more likely to happen. Contracts usually answer some sort of complex business plan, and obviously your IP was written because of your business plan. But if you actually carry out a contract, the business plans might be exposed, and IP or contracts can be used for deception. Now, I'm really not going to talk about it, but it's interesting to think about. How do you build your IP so it's easier to negotiate and easier to see that the contract is being fulfilled? So, maybe the IP being clear, being modular, maybe being scary. These are all possible things, but it's worth going into in more depth. Now we're negotiating the contract, but guess what? Maybe it's not an IP contract. That's not a reason to ignore the IP issues. Okay, so have your whole list of IP issues which you might want to make sure are taken account during negotiation, like what is the risk to the IP? Or is the IP tied to people? Now you're negotiating. According to the Harvard method, negotiation has to do with exposing needs from each side so you can find a better match. But not everybody agrees with that, and some people are worried that negotiation is actually a process of learning the weaknesses. And IP, I've already said, is weak, fragile. And we want to convince our competitor, partner, of course, to be in the place where the IP is stronger. Let's say covered by 20 dependent claims and not just by claim one. So you have to ask yourself, when you're negotiating, should you be explicit about these particular issues that bother you? And one of the ways that it's often done unintentionally is that you have particular contract clauses which match particular IP issues. And you have to ask yourself, do I want to do that? Why should you do it? Easier to check. Why shouldn't you do it? It might be difficult to write it, and it definitely exposes what you want. And depending on what your style of writing contracts and negotiating is, you might want the other side to understand your needs or not understand your needs. Okay, we signed the contract, everything's wonderful, we're starting to execute. So it's true that most IP disasters happen not at the moment of signing, but a few years later when everybody's gone and only the contract stays. But as when contracts are applied, there are reversing challenged IP-related activities, mouthful, different things that you do which are very difficult to turn back. Assignments, exposures of secrets, transfer of know-how. Once it's done, it's done. Exposing of your weaknesses, business realignment, cancel other contracts. You can damage trust, and trust is a type of IP. Sometimes the minute you sign the contract, the ecosystem hears it. What does that mean? It means that you have to have reversibility, some way of leaving the agreement before you get locked in. Because remember, the goal, perhaps of the other side as well, is to build a new moat using the contract so you won't be able to leave the contract. So one of the things you have to think about, I'm looking from an IP perspective, is have mechanisms for leaving without too much damage to your IP. Or conversely, using IP to prevent the other side from leaving before you want them to. For example, if you have the issue of exposing information between the parties to the contract, it means it's easier to audit it. It's also easy for you to tell if the IP is doing its job, and then maybe the next contract you sign is going to look different. Okay, we signed the contract, we started it, everything's fine. You have to monitor the contract, and I'm only going to talk about IP monitoring. And if there's money involved, or if ideas are supposed to flow, or data, or ownership, then you want to check for compliance with the contract. And the question is, does your contract have mechanisms for doing that? What about money? Okay, make sure that the IP is having the desired effect on money flow. What about third parties? They're not party to the contract, but how is their behavior changing because of the contract? And of course, yourself. Mentioned before, one of the jobs of the contract is to normalize you in a new position, lock you in. You need to monitor the contract and see if you're being locked in. Maybe you don't want that. And I'm talking about locked in using the IP. Now, let's say you forgot to put in an IP clause. Say, who owns inventions that one party makes but are valuable to the other party. Nobody believes it could happen. And suddenly you realize it could happen. Well, it's not too late to renegotiate. And of course, when you have a contract, you start worrying what's going to happen at the end. So maybe we need to file new IP specifically for those reasons. Okay, contract was for 10 years, 20 years, 15 years. It's over. Maybe you're starting a new contract. Who's allowed to terminate the contract? Let's say the contract terminated. What about the licenses? What about the IP rights? More generally, all sorts of survival clauses. You have to keep it secret. You sign an NDA, it's good for 3 years, but it says in it that the trade secrets have to be kept secret forever. Not the confidential information, but the trade secret. Confidential information needs to be destroyed and returned. Sometimes you get a contract which includes a perpetual license. It's not clear what that means, but it definitely sounds like somebody's getting something which lasts forever. Is a contract designed so that you have a sudden break? And remember, IP is good at sudden breaks. In a real setting, you don't have just one relationship, you have multiple relationships with multiple sides, and guess what? It's more complicated. You signed the contract, and I'm sorry to say, the business venture perhaps is failing, but definitely the contract is failing. Okay, what's going to happen with the IP? Will it be stuck in court so that nobody can use it? Can you prepare ahead of time IP in order to fight off attempts of the other side to enforce a contract on you? In a more general sense, you want to de-risk your IP issues. On the plus side, contracts can make punishment easier. It says where's the laws. It says where you go to court. It requires arbitration. It talks about how you get the damages. All of these are unpleasant, but they save a lot of lawyers' fees and uncertainty and allow you to do it quickly. And of course, if you do the contract properly, you're less likely to fail, or at least the fail will be soft fail. So before I mentioned that IP can be harsh, but IP can also be modulated by a contract to match the business needs. One of the things you have to ask, do I have, for enforcement, multiple orthogonal mechanisms? I can sue you on a patent, or I can close down the factory and stop giving you products. Okay, these two things are orthogonal, and they make the more easier to enforce the contract. If you don't follow the contract, I have two unrelated things I can do to you. Most contracts should start the other way around. Some contracts are IP contracts, assignment, royalties, NDA. These contracts are mainly about IP, and I think they're often a waste. Why? Because if you're already having a contract that talks about IP, you might as well leverage it and combine it with business issues in the contract itself. Sometimes you actually do have a contract which talks about both IP and non-IP and how they work together. Sometimes somebody tells you, oh, this contract, it has nothing to do with IP. I said at the beginning that it's not easy to avoid knowledge transfer, and any contract can be expected to create IP opportunities and IP risk. Even think about the question, do we leave IP on the table? No, leaving money on the table. IP should be in writing. It's expensive. The less detail you have in the contract, the more it's likely that defaults are going to go in, and the defaults are often not in your favor. And if instead of defaults you have assumptions, that's just another thing to fight about in court. Made here a list, of some types of contracts that patent attorneys meet, in their daily life. So licenses, which always have some sort of limitation. What I call small IP contracts, NDA, remember, not just secrecy. Warranties, when you have an investment agreement, I warrant that this and that I have the patent and that I'm not infringing and so on. Sometimes you have human contracts with an IP aspect, an employment contract, a founder's agreement, a consulting agreement, with an individual, an assignment. Of course, we want to know what you're assigning. Somewhat bigger, you do ongoing work with a subcontractor, distributor, supplier. There's always IP involved. Software licenses. Contracts which relate specifically to the creation of IP. Joint development, for example. Technology-based. A lot of tech transfer agreements are not just about the IP, but also about the technology. Different things. And you have contracts which are not about IP, but have a very important IP element, and these are M&A agreements or separation agreements, if the M&A didn't work. So guess what I'm going to recommend? When we prepare IP portfolio, independent of our business needs and so on, we should prepare in view of the contracts we expect to have. Now, obviously, these are not standard contracts. Okay, each contract is different, and therefore each, IP portfolio will be different. An advanced topic is using the combination of IP and contracts to build relationships. You can think of it this way, that IP rights define boundaries and contracts define pathways. And just as an example, a data funnel. I use a contract which is protected using IP to make sure that anything any one of my customers uses, the data comes to me so I can build improvements in the product. Okay, that's a very typical data funnel, and the contract has to say it's going to happen, but I need to have the IP issue set up correctly so that it can happen. And I'm reminding you we have two types of IP. The type you use only once, it blows up for each relationship, and the type you use regularly. And one of the things you should do, since you usually have a lot of contracts, is you want to see how these different levels that you have using the IP, how well they work, and modify your behavior and or your contracts. One level above relationship architecture is ecosystem design. Okay, so think of an ecosystem. I don't know, Tesla electric cars with chargers and whatever. And now ask yourself, why is it going to fail? One of the reasons it might fail is because one of the partners in the ecosystem starts not doing what's good for the ecosystem. And the combination of contracts which tell people how to behave and IP which restricts them in what they can do can help prevent that from happening. Now, not only can it help prevent it from happening, but the IP and contracts you use with your friends and with people who aren't your friends actually shape the ecosystem. If you're aware of it, wonderful. If you're not aware of it, maybe it'll happen randomly, which is not good, or maybe your competitor will take over. We talked a few months ago, a year ago, about how to take over somebody else's ecosystem. And there's different parts you can play in an ecosystem. So I said I'm not going to teach how to write clauses, but here's just a list of clauses that you should often expect to see in a contract. Who owns it? Who owns old IP? What about new IP? How do you calculate royalties? Confidentiality and other ways of not damaging. What's going to happen with the IP after the contract? And is anybody saying that they're not infringing, or they're not saying that they're not infringing? Mechanism for monitoring different things. And you should expect to see these. And here's what you should also expect to see, even though we don't want to see it. Somebody much cleverer than you or your client gives you a contract, and it says in it that automatically they get a license for 15 years, even if they decide not to do step 2. Or it says exclusivity. My product is a sandwich made out of white bread, and I'm licensing bread technology from a company, and I have exclusivity on white bread. Tomorrow it's going to be brown bread. Do sides have permission to design around? What is they paying royalty on? On screws or on cars? We're only going to pay you money if you have freedom to operate. Or here's a contract. We decide what you tell the patent office when you're prosecuting it. There's more. Last but not least, you cannot enforce all contracts. In particular, IP is a problem because IP clashes with antitrust. IP is about monopoly, antitrust is not. So depending on what you're doing, you can have antitrust, misuse, grant back, all sorts of anti-competition laws, anti-price fixing laws. And reminding you, IP is international. Law is different in each country. You have a lot of contracts with a lot of IP-related issues. I hope somebody makes an AI tool which helps you keep track of the IP effect of contract in a typical company. I suspect it's not easily available. In summary, it is not correct to say that contracts have IP clauses. I said IP is crystallized strategy, and it's part of a critical set of tools that we use. And when we write patents, we should already be thinking about the contracts. Also, what is considered to be non-IP contracts. Remember the dance of IP, contracts, and uncertainty. And I'll say it again, companies have a lot of contracts, and these contracts can contradict, be misaligned, and so on. So just to put you through the process, I have a company, Sustain, makes a product, Stain Away. Details are sadly not important, but what is important is Sustain does not plan on making the textile. It just wants to make Stain Away, which can spray on the fabric. And here's the order of the steps. First, what are your IP issues? And only after that, how should they be handled using contracts? Okay, I am stopping the recording.